Hello, everyone. Welcome to the Animal Legal Defense Fund's Animal Law Academy. My name is Alyssa Sander, and I'm the Animal Law Program Fellow here at the Animal Legal Defense Fund. Thank you so much for joining us today as we continue the Academy's brand new series. The Law Student Paper Series highlights the incredible scholarship by law students in animal law and provides a unique perspective on animal law topics for our members. There are also additional materials and resources from today's webinar that can be found on our website. Please go to aldf.org/webinars, click today's webinar, and you'll see them there. With me today is Benjamin Krieger. Benjamin is the third-year law student at Lewis and Clark Law School. Benjamin will be presenting their paper, Environmental Responsibility and Animal Protection, Overlooked by Pension Plan Regulation. Thank you so much for being here with us today, Benjamin, and I will turn it over to you.
Thank you so much for being here and for watching this video. My name's Benjamin, and I'm so excited to be here and to be involved with the Animal Legal Defense Fund. I also appreciate the opportunity to thank my numerous friends, professors, and mentors who assisted and encouraged me on this effort, and everybody at ALDF who has been so incredibly supportive and kind. I'm nearing the end of work on my JD at Lewis and Clark Law School. However, I aspire to continue as an LLM student someday. I'm fortunate to be this year's co-editor-in-chief of our Animal Law Review, student project coordinator for the Northwest Environmental Defense Center, NEDC, co-president of our Tax Law Society, and one of the student directors of our Academic Enhancement Program, which strives to keep legal educational opportunity and advancement open for students of all backgrounds. During my time as a student, I've been very fortunate to be involved as a volunteer in various other public comments on proposed rulemaking that impacts Pacific Northwest wildlife for brown bears, bighorn rams, rockfish, and threatened coastal birds. A transcript of this speech, the slides, the public comment I submitted on behalf of NEDC, and additional materials that are referenced will also be made available on the ALDF website. Additionally, I will include photo credits for the PowerPoint slides at the end of this presentation. Lewis and Clark is one of the leaders in environmental and animal advocacy, and it has been an amazing opportunity to be immersed and surrounded by such an inspiring community for the past 3 years. I have 3 main goals for this presentation. First, I want to explore some reasons why tax law and policy is an essential tool for animal advocacy and environmental protection. Second, I will briefly introduce the topics of ERISA, fiduciary duty, and ESG. And third, I would like to discuss why I think recent amendments made at the end of 2020 to the investment duties regulation of ERISA are problematic. So about 1.5 years ago, I was sitting in my tax class. I studied accounting in undergrad, so I was very excited to see something a little more familiar in law school. And I was wondering, as I think we should all be wondering, how does the thing that I am working on impact the environment and climate change and non-human animals? And if you happen to be working on trying to better understand the legal framework of our tax system, the answer is, well, surprisingly vast and complicated. Ozone depleting chemicals? Oh, we have a federal tax for those. See Internal Revenue Code section 4681. Are you in the business of raising animal livestock? Because if so, your tax obligations are likely substantially different and often more preferable from many other industries, especially in some states. See, for example, ORS 315.176 for Oregon's new bovine manure tax credit. What about racehorses? Well, even they have special treatment and a section of the code, again, back at the federal level, discussing them in some detail. See IRC section 168E3 Cap A. What about exotic animal breeders and private zoo owners? Several of them have ended up in tax court, having to defend the legitimacy of their claim deductions and business dealings. See, for example, Tax Court Memo 2007-376 for an example of disallowance of business expense deductions from exotic animal breeding operations. And what of non-human animal advocates? ALDF itself is a nonprofit organization, which is also all about the tax stuff. Its code section 501c3 provides preferential tax treatment to entities organized for prevention of cruelty to animals, among many other worthwhile causes, if they meet various requirements, and code section 170 provides a possible tax deduction for charitable contributions to such organizations. Tax law has a lot of important and profound impact on how society interacts with non-human animals and makes financial decisions about how we manipulate and modify our environment. One of my professors likes to say that all animal One of my professors likes to say, all law is animal law. And while I can neither confirm nor rebut that statement, I certainly can assert that tax law absolutely is an essential part of animal advocacy. And this can be evidenced by nonprofits like ALBF leveraging the code to maximize their important efforts on behalf of non-human animals with preferential tax treatment, or by politicians, particularly at the state level, and commentators who have criticized why something like a CAFO can get taxed more favorably than other less harmful and less toxic local business operations. But for this conversation, let's focus on how some potentially tax-privileged retirement plan investments are selected, specifically on those investments selected by financial professionals who has a legal and ethical obligation to make prudent investments, a fiduciary duty, because how those selections are ultimately made is important for all of us to consider. For instance, how should someone choosing how to invest your retirement funds on your behalf consider environmental, social, and corporate governance, ESG, factors? So climate change mitigation, corporate social responsibility, and animal welfare are a few common concerns that an ESG analysis and perspective might include. ESG criteria can help to better determine the future performance of a business, particularly in the long term, and can be useful in financial analysis, but can be difficult to categorize, and a universal standardization has remained elusive. Some investors hold the belief that beyond ethical concerns, ESG criteria can also assist by signaling potential economic risks or benefits that might otherwise not be appropriately weighed. However, ESG data is qualitative and can be difficult to quantify and verify in monetary terms. So there's investor demand for greater transparency and more readily available information. For instance, the Dow Jones Sustainability Index, despite providing very useful insights and helping raise awareness of ESG considerations, has referenced self-reported data of social and environmental impacts, which holds some worries about corporate bias and the credibility of those disclosures. There, selected companies are annually invited to participate in a corporate sustainability assessment questionnaire. And then the results of that questionnaire are compiled with a broad selection of other data and shared generally as a percentile ranking. The process has been audited by a third party, Deloitte, one of the big four accounting organizations, to help provide assurance and legitimacy to the process. This is not the only ESG reporting initiative, but it is an important player in the current ESG landscape and its development. The pandemic and the massive financial disturbances associated with it has also caused even stronger interest in ESG factors being included in prudent investing. And some ESG-focused companies have performed quite strongly during these difficult and uncertain times, with one analyst reporting that 81% of a selection of globally representative sustainable indexes has outperformed their parent benchmarks in 2020. 93% of 50 private equity executives surveyed also in 2020 indicated that focusing on ESG themes generates good investment opportunities. And so I just flipped the slide. Is this working now?
Yep, it is working great.
Okay, good. Sorry about the technical difficulties. It seems like all of the last year, right? So in 2015, Fiduciary Duty in the 21st Century, published with support from the United Nations, something that stated, failing to consider all long-term investment value drivers, including ESG issues, is a failure of fiduciary duty. Also in 2018, a significant petition, a copy of which has been made available with materials for this webinar, was made to the Securities and Exchange Commission for greater inclusion of mandatory disclosures relating to ESGs. One publication, also included in the materials that go with this presentation, states, fiduciary duties exist to ensure that those who manage other people's money act in their beneficiaries' interest, rather than serving their own interests. Decisions made by fiduciaries cascade down the investment chain, affecting decision-making processes, ownership practices, and ultimately the way in which companies are managed. Some institutional investors believe that environmental, social, and governance, ESG issues, were not relevant to their portfolio value and were therefore not consistent with their fiduciary duties. This assumption is no longer supported. However, the ERISA Field Assistance Bulletin, number 2018-01, stated, to the extent ESG factors, in fact, involve business risks or opportunities that are properly treated as economic considerations themselves and evaluating alternative investments, the weight given to those factors should be appropriate to the relative level of risk and return involved compared to other relevant economic factors. This bulletin is important because ERISA, the Employee Retirement Income Security Act of 1974, and the bodies of law that regulate employee benefit plans implements rules and regulations to prevent the misuse of plan assets by fiduciaries, managing those assets which are controlled by ERISA. Qualified retirement plans, such as some of those retirement plans controlled by ERISA, are also eligible to receive substantial tax benefits. Has caused a mismatch between shifting perceptions of what fiduciary duty is, prudent fiduciary duty, and what it should be, and also what the regulations for ERISA-bound fiduciaries actually is. To address that ambiguity, a rule was proposed in 2020, which in my mind and other critics makes it excessively difficult and burdensome for ERISA fiduciaries to include ESG factors in making their investment selections. Although the comment window was quite short, it was only open for about 30 days, I was able to propose and then submit a public comment on behalf of NEDC in response. Sadly, at the end of 2020, the Department of Labor and Employee Benefit Security Administration largely moved forward with their proposed rule. However, due to the substantial negative public response, which I was fortunate to take a small part in, a few of the restrictions originally proposed have been changed regarding the use of pecuniary factors by ERISA fiduciaries, non-pecuniary factors being the latest language being used by the Department of Labor for the concept of ESGs due to a lack of precise or generally accepted definition for ESGs, which leads back to that alternative suggestion that some sort of effort to standardize ESGs should be undertaken instead, perhaps by the Securities and Exchange Commission and implemented in transitionary phases. The final rule, in effect, creates a very narrow pathway for the use of ESGs and requires rather extensive documentation and added hassle, which I fear will have the functional effect of chilling their use by ERISA fiduciaries, despite how useful they can be. But the excitement hasn't stopped. A new president was elected, and in January 2021, Executive Order 13990, Protecting Public Health and the Environment and Restoring Science to Tackle the Climate Crisis, was made. I don't know who names that, but that's a mouthful. The result being that the agency action is to be reviewed. This is all incredibly exciting for me. This also caused some additional stir as another final rule issued at the end of the Trump administration on proxy voting, which I unfortunately didn't have the time to offer another public comment on, has some interplay with the rule under review. So as of March 2021, neither rule has reportedly been enforced. This is important and a current topic, not just for ERISA fiduciaries, but to the public in general. And I'm so grateful to have this opportunity to help add spotlight on it. This regulation influences and modifies the way capital is invested in our economy on a massive scale, which in my opinion should be directed more towards environmentally responsible and green investments for long-term stability and viability of our nation, as well as for the well-being of the future retirees that ERISA is explicitly intended to protect. I would note, with the change of administration, that this area of law might evolve further, as each of the more recent presidents has presided over prior shifts in the treatment of ESG, now non-pecuniary factors, by fiduciaries controlled under ERISA. A trend, it appears, that could likely continue in the Biden administration. I hope for another opportunity to author another public comment on the topic. So let's dive into this exciting and important topic in some greater detail. And let us start with a financial transaction that's likely on everybody's mind in some capacity, which is what to eat for our next meal. The world is full of interesting and exciting options. And so let's consider for a moment a steak dinner, aware that this is one choice of nearly an endless bounty of options most, but not all, people in the United States have the privilege of for their next meal. And setting aside the price, nutritional value, and potential enjoyment you might or might not receive from a steak dinner, a growing number of people might turn away from a steak dinner for several other possible reasons. A diner might object to the manner and method that a cow has been raised and slaughtered as maybe not meeting their ethical standards or their religious beliefs. A diner might be concerned about the environmental impacts of beef, both as cattle production contributes significantly to greenhouse gas emissions, and animal food products diminish water quality substantially more than nutritionally similar foods. A diner might be worried about the Amazon rainforest being cleared away at an alarming rate, in large part to produce more cattle. And gosh, sloths are quite adorable. Maybe I just don't want to endure a world without them. Keep hanging in there, buddy. A diner might be worried about the antibiotics often used in animal agriculture, contributing to the rise of antibiotic-resistant pathogens or other zoonotic diseases, which could result in a future pandemic with disastrous effects, similar to COVID-19. A diner might object to the treatment of agricultural workers and make particular note of the difficult and dangerous work that animal agriculture often is. But perhaps diners who choose not to have a steak dinner are weighing a wide variety of considerations as part of a broader and more complex reasoning, a balancing test that does not depend on any one factor alone. Whatever the cause, people who forsake steak for dinner are choosing to invest their resources in something else. And this activity can be, it can have a very powerful impact. Consider the impact of various boycotts and how much of a lasting effect they've made on a society. How we spend and how we use our resources has a dramatic and lasting impact on the world in which we live. It flows quite reasonably that animal and environmental advocacy has focused a lot of energy on what we choose to eat, what we choose to buy, and what we choose to minimize our consumption of. And that's a fantastic start. It's an excellent foundation. However, unfortunately, we can't depend on amazing photos of vegan food on Instagram alone to save the world from climate change and the intolerable suffering, both human and non-human, inherent in our current food system, although they surely do help. In order to efficiently and productively transition to a more sustainable, equitable, and compassionate economy, we need to also dive into the underlying financial and legal framework with our advocacy efforts. At least presently in the United States, two major financial topics of discussion are healthcare access and retirement savings, which are both closely tied to employer-employee relationships. For those Americans who have current health insurance coverage or some sort of retirement savings, most, although not all, will have, or have had some sort of interaction with their employer or a family member's employer for these common employee benefits. You likely have had or someday will have a health insurance policy and retirement savings plan with an employer. And if not, you might have one with one of your employees if you own your own business. Consider the roughly $6.5 trillion currently held in 401k accounts, an employer-sponsored defined contribution retirement plan, with the term 401k coming from the relevant section of the Internal Revenue Code, which provides a tax incentive. This is roughly a fifth of the USA's retirement savings market, but in a recent survey, 2/3 of Americans report being uncertain how 401k plans work. That's a huge problem. In contrast to defined contribution plans, defined benefit plans, such as traditional pension plans, are another type of retirement plan available that can also qualify for tax advantages. Our government has had some interest in encouraging people to carry health insurance and to plan for their retirement. Legislation has been implemented to encourage this behavior in the marketplace. The desire is to keep Americans healthy and productive, as well as being able to realize their dream retirement as a daring and handsome advocate for all sloth kind. Anyways, it's important to also note that an employer could offer other employee benefits, such as vegan catering, electric vehicle parking and charging, or a personalized calendar featuring the world's slowest mammal. But those are less common employee incentives. It's largely been a two-pronged effort to promote widespread adoption of health insurance and retirement plans among the population. It depends heavily on employer involvement and employer incentives. Firstly, the government has offered very substantial tax incentives related to employee benefits that follow the highly technical requirements, particularly for healthcare costs and for retirement investments. These tax expenditures, worth billions of dollars, represent a major part of our national tax policy. Secondly, the government has been heavily involved in the regulatory oversight of these markets. ERISA does not go about protecting plan participants and their beneficiaries by requiring employers to provide any set of minimum benefits, but instead controls the administration of plan benefits, noting a few important exceptions, with administrative oversight, criminal sanctions, and by establishing a comprehensive civil enforcement scheme. Despite these efforts, which are substantial efforts, many people in the United States lack adequate funding to meet their healthcare and retirement needs. While there are some important exceptions and exclusions, not all employee benefits are controlled by ERISA. The law provides a great deal of the federal statutory framework impacting employee benefits. There is a substantial corresponding body of ERISA case law, particularly on topics such as state law preemption, available remedies, and claims. Due to the broad-reaching and ambitious nature of employee benefits law, ERISA is also modified and impacted by several other pieces of relevant legislation, such as the Americans with Disabilities Act, COBRA, HIPAA, PPA, and the ACA, just to name a few. Further, because of this dual function as both labor law and tax law, employee benefit law is substantially codified in both Title 26 and Title 29 as a sort of Gemini in law, with significant regulations coming from both the Treasury and the Department of Labor correspondingly. The IRC provisions and associated regulations and legal authorities set out the highly technical requirements needed to receive beneficial tax treatments available for qualified retirement plans. Like many areas of tax law, details shift from Congress to Congress, administration to administration, and tax year to tax year. While all of this makes tax law surrounding employee benefits the most interesting and I think the most exciting area of law, it also makes it particularly complicated and difficult to understand. Effectively, this means that despite most people having some sort of relationship at some point in their life with an employee benefit, it can be particularly challenging for employers and employees to understand the finer details of the rights and obligations around them. One key distinction in ERISA is between pension plans and welfare benefit plans that employers might offer. Pension plans can, for example, result in a deferral of income realization, very beneficial for tax purposes, until a later time, such as retirement. Welfare benefit plans can, for example, provide other types of benefits, such as healthcare, to an employee and their family member, or provide severance benefits during a time of layoff. The compliance requirements for each is unique. And it's noteworthy that ERISA does not mandate or require any type of benefit plan to be offered by employers to their employees, but rather offers potential tax benefits. Often excluded from these substantial tax savings and advantages are those who do not receive such benefits from their employment activities. Smaller businesses can also be particularly burdened and disadvantaged relative to their larger peers by the complex and ever-shifting legal framework. In turn, this can have disproportional impacts on pre-existing socioeconomic, racial, and gender inequalities. This further amplifies inequalities in the workforce. In short, there's a tremendous amount of good that can be accomplished in this world and in service to society with a background understanding of employee benefits law. And so, in glorious sloth-like form, we're finally at the start of the topic, which is really the heart of this presentation. To effectuate the benefits promised by plan sponsors to plan participants, vast sums of money are held by fiduciaries and co-fiduciaries for the future use and benefit of plan beneficiaries for a potentially substantial period of time, several decades, in fact, in my personal instance, until retirement. Reasonably, the law has a lot of restrictions and requirements on plan fiduciaries to act appropriately with the extraordinary responsibility they carry and are entrusted with. So I'm paralleling myself a little bit. As a kid, there were these stuffed animals called Beanie Babies, and they were hugely, hugely popular. And part of the popularity was to collect and save them in pristine condition, of course. And this was sort of seen as a very questionable investment activity. As a toy that promotes investing and savings, perhaps collecting Beanie Babies was a genius. But as an actual investment vehicle and the toys themselves, it's highly sketchy. You're probably not going to make millions off of your old Beanie Baby collection, probably. No one really knew what the internet was. It was the 90s. Everybody was listening to the Spice Girls. It was a much different time. And people investing in stuffed animals, or at least kids investing in stuffed animals, even if it never made much sense, was a huge fad. One could imagine on retirement, someone handing over the keys to a storage unit full of Beanie Babies, and the beneficiary, the person who's depending on this for their retirement, being really, really disappointed, right? So tell me what you want, what you really, really want. I want a fiduciary responsibility provision. Okay, so we definitely need rules. Perhaps also some rules against me singing on camera, but we need strong rules outlining fiduciary duty to prevent things like the exclusive investment in Beanie Babies contained inside a storage unit as a retirement savings strategy. It's not a good one. Part of why we need strong rules, aside from people depending on this for their retirement, is that it is not always particularly obvious to the average plan participant, perhaps even the average plan sponsor, exactly what is going on financially behind the scenes. We depend on financial professionals. Without those rules, investments like that, or worse, could become tragically common, and the whole purpose of ERISA would be undermined entirely. Losing your retirement savings is not a good way to spice up your life. So let's rip off some heart-shaped swing tags and take a look at ERISA section 404, which is actually found in 29 U.S. Code section 1104 because, sure, that keeps things interesting. And I'm not making this part up, outlines the prudent man standard of care that a fiduciary owes to plan participants and beneficiaries. Could I win an election to Congress on the platform of changing that to the prudent person standard of care? I mean, I can only speculate, but the language feels, at the very least, awkward and horribly outdated. Anyhow, the prudent man standard of care requires that a fiduciary discharge his duties, noticing a trend here with the excessively gendered language, with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent man acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims. And I would read this, even without any guidance or insight, that the storage unit full of Beanie Babies as a retirement plan will be very problematic here, and for very good reasons. The US Department of Labor, their website, currently elaborates and perhaps oversimplifies with the statement that the primary responsibility of fiduciaries is to run the plan solely, again here, solely, in the interest of participants and beneficiaries, and for the exclusive purpose of providing benefits and paying plan expenses. Fiduciaries must act prudently. So, what is the care, skill, prudence, and diligence of the prevailing prudent person? We're going to stick with person. We are faced with an overwhelming amount of scientific evidence of the very real threat of climate change, the potential financial and national security disaster caused by climate change, and the tangible reality that these risks will occur sometime in the expected lifespan of future plan beneficiaries, such as Beanie Baby loving millennials like myself, whose interests the law is explicitly intended to protect. We could say the same for the future zoonotic diseases produced in some substantially foreseeable part, perhaps, by our current standard animal agriculture practices surrounding CAFOs and routine antibiotic use. I find myself in agreement with the report published with the help from the UN that to deny the hard science of these risks, at least in my mind, is to lack an appropriate or reasonable level of care, skill, prudence, or diligence of a prevailing prudent person in planning for the future. I hope to retire in 30 or 40 years in the future, and I have a strong interest with my retirement investments and that future world still being in a state suitable for my future retirement. Part of my future financial welfare is continued access to clean water, clean air, effective medications, a relatively stable economy, and to be free from excessive warfare exacerbated by poor resource management and planning right now. Fiduciaries bound by ERISA have some of the strongest fiduciary duties found in law. And at least to me, it seems very prudent to consider the very real pending financial risks and opportunities presented by climate change and a 40-year-long investment. To ignore the impact of climate change to my retirement is not prudent in the prevailing circumstance, and, at least I would suggest, not keeping true to an obligation of fiduciary duty. So let's take a look back at our earlier discussion about what to have for dinner, steak or no steak. For me, well, for some, this is a clear and easy decision based on a single factor or two. But for at least some, presumably reasonable persons, we might choose to adjust our consumption and purchasing habits, mindful of how they impact the greater world around us, which in turn, as a collective average, impacts our future and the futures of our loved ones. In fact, for any free market-based solution to climate change to be effective, at least some of us have to be willing to adjust how we invest our money in response to climate change. We could reason that the youngest among us has the largest personal incentive to focus on ESG factors, and that such investments, certainly in the long term, will be prudent. We still need strong rules, of course, lest our retirement devolves into a storage unit full of Beanie Babies and I start singing again. But perhaps we also need some sort of room for innovation and how to fully assess the risks, the liabilities, and the investment opportunities that climate change will present. Specifics of how we do so, however, it remains a work in progress. So I suggest we should implement some sort of standardization for ESGs that is slowly implemented and updated to eventually be a requirement of prudent fiduciary duty. Still considering dinner, let's propose a very different rule when it comes to selecting what to eat. One where you may exclusively consider the taste, the nutritional value, and the cost of steak, and it completely bars you from thinking about climate change, animal cruelty, or social inequalities when deciding what you will have for dinner, without providing a large amount of documentation, and even then, in limited circumstances, such as a tiebreaker between two options. Surely, without considering all of the factors that genuinely follow with meat consumption, a lot of people who might otherwise make a different option with the benefit of considering all of the available information are compelled into picking steak for dinner because they're only considering some, not all, of the relevant factors. Ultimately, this rule is a good analogy for the one recently implemented. It's very unfortunate. Rather than providing much needed guidance for making sound financial decisions in light of the total facts and circumstances currently prevailing, the latest regulation for ESGs, or pecuniary factors, strongly restricts their use by fiduciaries managing ERISA plan assets. What benefit does this have, particularly for those of us who will not see retirement at the earliest for decades? It seems quite harmful to me. We should instead balance that harm of ignoring scientific fact with the other harms of an unclear, ambiguous or uncertain standard for fiduciary duty. And we should do so with a reasonable and evolving approach, implementing some sort of standard gradually over time so that both markets and fiduciaries have the opportunity to appropriately adapt to new compliance standards, while those standards gradually evolve. Preventing fiduciaries from making a sound decision based on all of the available scientific facts has a very hefty cost that should be adequately weighed against other interests, such as certainty, stability, ease of use, dependability, and the regulatory framework for our shared future. In short, I'm not trying to tell fiduciaries what to have for their metaphorical dinner, but they should at least be allowed to always consider all of the relevant facts involved without running afoul of excessive government restrictions on reasonable, prudent, and proper consideration. To quote former Vice President Al Gore, outdated conceptions of fiduciary duty cannot be allowed to stand in the way of progress towards a better economic system. If you've made it this far, thank you so much for giving me your most precious resource, your time. I hope that this speech has inspired you to think about and discuss tax and employee benefit law and policy, or if not, at least it's been a little amusing. I very much look forward to any of your questions. Thank you.
Great, thank you so much, Benjamin. This was a topic that I knew nothing about going into this, and I feel like I really learned a lot, so thank you. And so we have some time for questions, so let's just dive right into them. My first question that I'm wondering is, what motivated you to write on this topic?
Sure. I really wanted to take a class that looked at how tax law and policy impacts non-human animals. And I was really quite fortunate that my school and my professors allow me to undertake a 2-credit independent research project in that topic area in the spring of 2020. And I identified some areas and issues I wanted to explore, and eventually focused on regulation of fiduciary duty under ERISA and what role ESGs could or should play. Mindful that I was looking at that 2018 bulletin because the 2020 rule hadn't been proposed yet. And so later that summer, the proposed regulation came out on the same subject. I jumped at the opportunity to begin pivoting the original independent research project into the public comment, which I was fortunate enough to eventually submit. Critical of that prior regulation, it was really unfortunate to see things kind of going in the opposite direction of what I had hoped would happen. So, with the new administration, I hope that this area of law will continue to develop because I think it's really important, and it's very exciting for me too.
Yeah, it's really cool that you were able to kind of create a independent study that merged two of your passions together. And lucky enough, as your professor said, and I think I've heard plenty of my professors in the past say too, is animal law really is in every type of law, and this just goes to kind of show it. So that's exciting, and hope that you get with the, administrations to come, you got to get some new exciting, updates, and maybe you can update this.
Yeah, that would be amazing. I hope so.
And so our second question is, could you give an example of how ESG factors could have an impact on animal welfare objectives when considering two different investment choices?
Yeah, of course, and thank you so much for asking. So a financial forecast made in 2020 anticipates that plant-based milk beverage market will reach $21.5 billion by 2024, growing at a projected compound annual growth rate of 10.18% between 2020 and 2024. And that market has an estimated value of only 11.9 billion in 2017. So that's pretty remarkable. Reported sales of plant-based milk beverages, which feels like a weird way to call like cashew milk or almond milk or oat milk. Anyways, they've increased by approximately 9% in the year prior to June 2018. This is while sales of traditional cow milk during that same time fell by 6%. And so these considerations alone are interesting, but they don't really convey the full benefits that plant-based milk alternatives could potentially offer as a long-term investment choice. And I mean, aside from being a pretty awful situation for the cows involved, dairy milk is very resource intensive to produce, which causes a great strain on our environment, particularly relating to water and water quality concerns. And if the cows are treated with antibiotics, dairy milk production in intensive agriculture settings could contribute to future antibiotic resistance and human pathogens and the rise of new zoonotic illnesses. Externalities, sort of these things that are on the periphery, such as these, can be very difficult for us to evaluate in monetary terms, but yet they do produce material long-term risks and potential costs. Intensive agriculture also has other social impacts as well. I'm sure that it can be an incredibly hazardous job for dairy workers, and they are oftentimes treated very poorly. And the dairy industry also receives a lot of preferential financial and tax treatments by our government, all of which is very tentative. So some or all of these factors might influence future demand, both for the product itself and as an investment in the manufacturers who produce it. So as consumers become more conscious of these concerns, it can have an impact on your investment. This comparison, of course, of these two consumer products as possible investment options is merely my personal speculation and shouldn't be relied on for any investment purposes. But I think that's a good example whenever we look at plant-based milk compared to dairy milk. There's this financial side of it might be a good way to go, but there's also this sort of social and environmental side of it, which also makes it perhaps a good way to go is enjoying plant-based milk, either to drink or to perhaps invest in, perhaps.
Yeah, that's really interesting and a great answer. When I drink my plant-based milk, I always think of it for, social, environmental, and, animal purposes, but I hadn't thought of the investment side of it. So always good to open that lens.
Hopefully more people are buying those products so that there's more demand and so that more options can be available for folks.
Yeah, absolutely. And so our next question is, you've talked kind of about balancing factors, and you mentioned Justice O'Connor's balancing tests. Could you elaborate on those a little bit more?
Yeah, absolutely. I absolutely love Justice O'Connor. And, I don't always agree with her conclusions. That's probably the case with everybody. But I really admire and appreciate Justice O'Connor's reasoning and analysis, particularly whenever it comes to balancing competing interests in fact-intensive situations. And I think that sort of analysis could be very useful when considering how to appropriately evaluate ESGs and if they could or should be applied in the context of fiduciary duty. Obviously, we want to prevent something as bad as like the stockpiling of Beanie Babies as an investment strategy by fiduciaries who are responsible for something as critical as their retirement savings. Yet I feel like hopefully we can trust financial professionals with a little more room to adapt and react to increasing risks of climate change than the ultimate 2020 regulation allowed. I'm not sure if a bright line rule or an unwavering standard really makes sense in this instance, as our understanding and our knowledge about climate change impacts and about other impacts to the world, sort of our knowledge is expanding and growing always. And so whenever it comes to our great legal minds on this type of problem, I'm just really strongly reminded of Justice O'Connor, who does such a great job at looking at those really complex fact situations and coming up with a great way to balance different interests.
Yeah, that's a good as a lawyer, I went through law school and read plenty of balancing tests, and it's a good thing to take into consideration just in everyday life too. So
Yeah.
I'm glad you could elaborate on those a little bit more. And so we have time for one more question. So our last question, this is a good one. During this presentation, you invited us to consider what benefits we might want from employment. What benefits would most motivate you from your employer, and how might you encourage them to do these things if they don't already?
Oh, yeah. At least for me, like some great vegan and gluten-free food options, obviously, are just a huge perk and a huge motivation. Healthcare and retirement, that's nice, but don't get me wrong, but nothing beats like a really great like soy curl shawarma fries, or I don't want to say like that's the only reason why I showed up to the Salif events at school, but it was a strong factor in the balancing test.
Yes, that's great. Free, vegan food is always very enticing. So
Exactly.
it got me to those events as well. So thank you so much to Benjamin for providing us with a closer look of ERISA and recent regulatory changes that can be problematic for human and non-human animals. And thank you to everyone for being here with us today. Please be sure to take the survey that pops up at the very end. And this does conclude our law student paper series for now, but students, please be sure to keep an eye out this summer, as the application will be opening for the next round. So if you were interested in these and you are thinking about doing one, we will have another round. And so that's it for us today, and we hope everyone has a great week.